Meghan Markle's lifestyle brand just got handed its second consecutive extension by the US Patent and Trademark Office. On the surface, that barely sounds like news. But 2 years into the process, her own brand name still isn't legally locked down in its home market, and the reason it keeps getting delayed is a lot more interesting than the paperwork makes it sound. Here's how a jam and candle brand ended up in a slow-motion legal holding pattern, while a nearly identical rumor about her kids got debunked within 24 hours of going viral. Let's start with where things actually stand right now. As Ever launched in the spring of 2025, and by most measures, it's been one of the more visible commercial wins of Meghan's post-royal career. But trademark protection in the United States doesn't work the way most people assume. Filing an application isn't the same as owning the mark. Before a registration becomes final, the applicant has to prove the brand is actually in commercial use. And that step is exactly where As Ever keeps stalling. According to filing records, the USPTO has now granted Meghan a second 6-month extension just to file that statement of use, nearly 2 years after the original paperwork went in. That detail matters more than it sounds like it should, because these extensions aren't unlimited. The Patent Office requires a fresh request every 6 months, and if one doesn't land in time, the whole application can be abandoned outright. So this isn't a rejection, it isn't a legal crisis either. But it does mean that for 2 straight years, the actual ownership of the As Ever name in the US has remained technically unresolved, while the products themselves have been selling the entire time. Compare that to what happened overseas, and the contrast gets sharper. In Australia, the same brand's trademark was approved back in June of last year, registered under a category broad enough to cover skincare, self-care products, podcasts, and even educational seminars, well beyond what's currently sitting in the US pipeline. That approval came without the repeated extension cycle the US filing has been stuck in, and it happened just ahead of a planned 4-day visit to the country with Prince Harry. When GB News asked a spokesperson about the international expansion earlier this year, the response downplayed it, calling the idea speculation and saying no firm decisions had been made about entering new markets yet. The paperwork on file in Australia already tells a different story than that comment did. Then there's the part of this saga that actually went viral for the wrong reasons. In April, multiple entertainment outlets ran stories claiming Meghan and Harry had specifically filed to trademark their children's names, Archie and Lilibet, timed to a Mother's Day product line that referenced both kids by their birth dates, including 2 separate candles tied directly to each child's date of birth. The story spread fast, the way anything involving the couple's children tends to, but it didn't hold up. Within a day, a follow-up report citing People magazine stated flatly that no such filing had actually been made for the children's names specifically, despite the Sussexes reportedly taking other steps to secure associated domains, email addresses, and social handles. 2 completely different claims about the same brand, both treated as fact, less than 24 hours apart. Which says less about the Patent Office and more about how quickly a plausible royal story can outrun whatever's actually true underneath it. None of this is unfamiliar territory for this particular family either. Rewind to 2020, right after the initial split from royal duties, and you'll find something close to a preview of this exact pattern. Harry and Meghan filed to trademark Sussex Royal for their new foundation, and the announcement alone triggered a wave of copycat filings from unrelated third parties trying to claim the name first, everything from communication services to household goods, filed by parties who had no connection to the couple at all. Some of those disputes dragged on for years afterward, and legal analysts at the time noted that a formal opposition to the UK application could have put the entire international filing at risk if it wasn't resolved cleanly. The current As Ever situation is nowhere near that chaotic, but it's a reminder that trademark protection for this family has rarely stayed the quiet background process it usually is for other brands. It keeps turning into its own headline. To understand why the US filing specifically keeps stalling while other markets clear fine, you have to look at what's actually required at this stage of the process. A trademark applicant in the US files based on either current use or intent to use. As Ever appears to have gone the intent to use route, which means Meghan's team has to formally demonstrate the brand is generating real commercial sales before the registration can finalize, not just that products exist on a shelf somewhere. That's a documentation step, and it's one a lot of growing brands stumble on, especially ones expanding into as many product categories as Ever has. Earlier filings tied to the brand, back when it was still operating under the name American Riviera Orchard, already showed the scale of what was being claimed. Trademark applications obtained by people and filed with the Patent Office listed everything from cosmetics and skincare to yoga equipment, gardening gear, pet accessories, jewelry, and jarred food products, essentially trying to cover nearly every lifestyle category at once, right down to lockets and ring holders. Filing across that many categories simultaneously is exactly the kind of thing that can slow a statement of use down, because each category technically needs its own proof of active commercial use before the whole application can move forward together. So what does an unresolved US trademark actually put at risk while all this plays out? In practical terms, it means a competitor could, in theory, use a similar name on similar goods while the registration sits pending, since full federal protection doesn't fully kick in until registration is complete, not just filed. It also means that every time a renewal deadline comes up, the brand's ownership status becomes public record again, which is exactly what's happening right now with this second extension. That's not a legal emergency, but it is a paper trail that keeps refreshing itself every 6 months, whether the brand wants the attention or not, and it's the kind of detail that trademark attorneys covering celebrity brand launches say is worth watching closely, since a lapsed extension is one of the more common and avoidable ways a growing brand can lose ground it already built. There's also a wrinkle in the 2020 Sussex royal saga that's worth sitting with for a second, because it explains why trademark lawyers who cover this family tend to watch every filing closely rather than assuming it's routine paperwork. At the time, 6 separate applications for the mark Sussex Royal were filed with the US Patent Office by parties with no connection to Harry or Meghan at all, including one filed by a California intellectual property attorney within days of the couple's announcement. Legal commentary from that period noted that because the US, UK, and Australia are all what's called use-based jurisdictions, meaning a mark has to actually be used commercially to hold up, the flood of copycat filings created a genuine risk that the Sussex's own international application could collapse if their UK filing ran into a formal opposition. It never fully collapsed, but the episode set a precedent that this family's brand names attract exactly the kind of attention that turns a quiet legal process into a running story, and as ever appears to be following a milder version of the same script 5 years later. Zoom out, and the bigger picture here isn't really about a missed filing deadline at all. It's about what happens when a lifestyle brand tries to scale into international markets while its home country foundation is still technically unfinished. Australia is locked down. The US isn't, not yet, not after 2 years and 2 separate extensions, and there's already a built-in reason this story doesn't end here. The next renewal deadline is sitting on the calendar right now, 6 months out from this most recent filing, which means either the paperwork finally clears this time, or this exact story runs back one more time when that date arrives. What's actually notable, looking at the full timeline together, is how differently this brand has been treated depending on which office is reviewing it. Australia cleared it in one pass with a wider scope of coverage than the US filing has managed to lock down after 2 full years. The kid's name story shows how fast a rumor about this specific brand can spread and get corrected almost as quickly, sometimes within the same news cycle. And the historical pattern going back to Sussex Royal in 2020 shows this isn't the first time a name tied to this family has ended up more complicated to protect than it looks on paper. As Ever is a real, functioning, selling brand right now, with a genuine commercial footprint across candles, spreads, and lifestyle goods. It's also, technically speaking, still waiting on the one piece of paperwork that would make its ownership official in its biggest market. Whether that resolves cleanly the next time the extension deadline hits, or turns into extension number 3, is the actual open question sitting underneath all the finished product photography. There's one more layer to this worth flagging, because it changes how the next 6 months should actually be read. A second extension isn't unusual on its own. Plenty of legitimate, functioning brands take the full allowed window to file their statement of use, especially when they're expanding across as many categories as Ever has claimed. But it does mean the clock is now genuinely tightening. Under standard USPTO rules, an intent-to-use applicant typically gets up to 5 extensions total before the window closes for good, so this isn't an open-ended process that can drift indefinitely. It's a countdown with a small number of chances left on it, and each one requires fresh paperwork proving real commercial activity in each category claimed. For a brand this actively expanding, hitting that bar across cosmetics, food products, home goods, and everything else on the original filing is a genuinely heavier lift than it sounds, which is likely the actual unglamorous reason this keeps stretching past deadline after deadline rather than any deeper controversy behind it.